You just got blocked on social media. And the Supreme Court said today, in a lot of cases, that's just fine, even if the person blocking you is a local, state, or federal government official. The justices said in a unanimous ruling, generally, those government officials have their own constitutional rights to block you from their social media pages. And in doing so, no, that does not infringe on your constitutional First Amendment rights. So here's what's going on. Today, the justices issued this 9-0, 18-page ruling written by Justice Amy Coney Barrett in the case called Lindke versus Freed. The First Amendment generally prohibits government employees from censoring public comments or blocking access to a social media account that offers official communications. But today's ruling says that is not absolute, and the justices established a new test to determine when a public official can block or delete your comments from their social media pages. Now, the test is a little technical, but stick with me. I'm going to give you some examples to help you understand it. First, you have to understand the justices said, according to this new test, it doesn't matter if we're talking about a public official's personal or private social media page. The ruling says it's about the substance of what that official is posting that matters to this test, not the label that they have or the title that they use on their profile. The new test says the only way a public official violates your rights when he or she blocks or deletes you is if that public official meets two requirements, and both have to be met. One, they possess actual authority to speak on the state's behalf on a particular matter. And two, they purport to exercise that authority when speaking in the relevant social media posts. So what the hell does that mean? Here's an example. If a city manager posts a photo of her dog on her personal social media account, talking about how much she loves her dog and it's her dog's birthday, and then you go onto that post and you start firing off comments about how much you disagree with her politics and you don't like the way the city is spending public money and you don't like her, and you get blocked, under this new test, the courts will likely side with the city manager because the substance of that post was personal. It was about her dog, and you're out of pocket for criticizing her about her work as city manager. But if that very same city manager on that very same personal social media page posts about a multi-million-dollar new road project that the city council is voting on, and you go onto that post and you fire off the exact same comments about how much you disagree with her politics and you don't like the way the city is spending public money and you don't like her, and she blocks you because of that, now she has violated your First Amendment rights, and if you can prove that in a court, the judge or jury will likely side with you. Now, if you want to read this ruling, I will email it out to you tonight in my News Girl News Roundup email, so make sure you sign yourself up.